What you're about to witness is one of those courtroom moments where every word matters. A man stands before a Texas judge facing a second-degree felony charge, indecency with a child by contact. That means the stakes could not be higher. This is the kind of charge that can carry years behind bars, life-changing restrictions, and consequences that follow someone forever. But this hearing quickly becomes more than just a reading of charges. It becomes a case about accountability, mental health, family support, and whether rehabilitation is possible under the law. Watch closely, because the judge in this courtroom is sharp, direct, and clearly paying attention to everything, from the defendant's understanding of his rights to something as simple as how he showed up dressed for court. That may sound small, but in a courtroom, details matter. Respect matters, responsibility matters, and then comes the real question. Should this defendant be sent straight into punishment or given one chance under strict supervision to prove he can change? You'll hear discussions about deferred adjudication, sex offender supervision, disability status, and a family stepping forward to take responsibility. But will the judge accept the agreement or decide something harsher is necessary? Stay to the end, because the final ruling comes with strict conditions, serious warnings, and a reminder that one wrong move could change everything. And as you watch, ask yourself this: when someone faces serious charges but also serious personal struggles, should the system focus more on punishment or prevention? Let's get into it.
What you're charged with is indecency with a child contact. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. The court is calling 2022 CR 1107, State of Texas versus Angel Cantu. Can I have parties announced for the record for the state?
Michael Villeria for the state.
For the defense?
A Boston Major for the defendant.
All right. Thank you for dressing appropriately for court. I mean, he's bringing shame to some people. Hey, it's not you, Mr. Villarreal. You always dress to impress.
I know I'm not dressed the best today, Judge, but I'm trying.
No. All right. Counsel, I'm showing you the discovery acknowledgement. Did you review that discovery with your client, and have you received all the discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, the state's just proceeding on count 1 and waiving and banning count 2.
Any objection?
No objection, Your Honor.
All right, Mr. Cantu, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is indecency with a child contact? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty?
Right here, the judge is doing something extremely important that many viewers miss in plea hearings. She's creating a clear record that the defendant understands exactly what he is giving up. By pleading guilty, he waives the right to a jury trial, the right to confront witnesses, and the right to remain silent. Courts take this seriously because a guilty plea must be knowing and voluntary. If there's confusion later, this transcript becomes critical evidence that the defendant was fully informed. Notice how many times the judge asks, "Did you understand?" That repetition is intentional. It protects the integrity of the process and prevents future claims that the plea was rushed or coerced. This isn't just routine paperwork, it's constitutional procedure. But here's the bigger issue. When someone says yes over and over in court, do they truly understand everything, or are they just trying to get through the moment? That question becomes even more important later when mental health concerns are raised. Let me know in the comments. Should judges do even more to confirm comprehension in serious felony pleas?
And sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. There's a $1,500 fine. And Brent, I'm sorry. I realize I'm talking very fast. All right. So, that's just me warming you up. But now I'm about to slow it down.
Go do slow.
I'm not going to be like the turtle on the cartoon where he's talking very slow. All right. The state recommends deferred adjudication, Chapter 62 compliance, and there's to be no contact with the complainant. Do you understand that? Is that the plea bargain agreement defense?
Yes, Judge. it is.
State.
Yes, Your Honor.
Next, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes,
Did you
ma'am.
understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 10 years and there be sex offender supervision. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. At this time, state offers state's exhibit number 1 and its attachments.
No objection.
Mr. Cantu, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
The court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, but the court will defer finding of guilt as you've applied for.
Now the case shifts dramatically from guilt to sentencing, and this is where human factors start weighing heavily. Defense counsel introduces autism, bipolar diagnosis, disability status, limited education, and a support system led by grandparents and even great-grandparents. That is not random sympathy material. In sentencing, lawyers present mitigation, facts meant to explain circumstances and argue for supervision rather than incarceration. This doesn't erase the seriousness of the charge. It doesn't excuse criminal conduct. But sentencing courts often weigh whether a person can safely function under structure, treatment, and monitoring instead of prison. The presence of family in court also sends a message. Someone is willing to help enforce compliance outside the courtroom. And let's be honest, the emotional impact here is real. Seeing elderly family members step forward to carry responsibility is powerful. But should family support influence sentencing in serious cases? Some people say yes, it increases accountability. Others say no. The offense itself should outweigh everything else. Where do you stand?
Deferred adjudication. Are we proceeding with sentencing?
State would waive PSI.
Yes, Your Honor. We'll proceed.
All right. And I'm assuming the complainant in this case is aware of the agreement?
Yes, Your Honor. We spoke with mom this morning, and she's understanding and agrees with the state's recommendations.
Okay. All right. Anything you want to say on behalf of your client?
Yes, Your Honor. My client, Angel Cantu, he is severely autistic. His autism was not diagnosed early in his life, and I think that's kind of the root of some of his issues. He is diagnosed bipolar. He's 100% on disability, Your Honor. He's only made it to the 9th grade. his great grandparents and grandparents are here today supporting him. That's his support system that is going to help guide him should the court accept the plea agreement.
Okay. How old is his great grandparents?
I'm not sure how old they are, Your Honor, but they're present.
82.
Are you all ready to take this on?
Yes, ma'am.
Okay. All right. I just want to make sure they're ready to take things on with you. All right. Now I understand the agreement. All right. Mr. Cantu, here's the thing. I understand that everybody has issues in their life, but you're going to have to work hard not to have anything like this occur again. You understand?
Yes, ma'am.
All right. So you have your great grandparents here, which is unusual. Usually people don't have their great grandparents. So I'm sure you've heard what I've told everybody else. When you live with your great grandparents, their rules go.
Yes, ma'am.
And did they dress you for court this morning? Tell you what to wear?
They provided.
Good job, great grandparents. Yeah. They did an excellent job. All right. So I take back what I said about everybody else because his grandparents helped him, his great grandparents.
Here comes the ruling, and it's a major turning point. The judge follows the plea agreement and grants 10 years deferred adjudication probation instead of an immediate conviction and prison sentence. That means the defendant is not formally found guilty at this moment, but if he violates conditions, the court can revoke that status, enter a conviction, and sentence him up to the full legal range. In other words, this is not a free pass, it is a suspended cliff edge. Then listen to the conditions stacking up. Sex offender supervision, no contact with the complainant, registration requirements, reporting obligations, proof of prescriptions, proof of disability or employment, residence restrictions, field visits, and close monitoring. This is highly structured supervision. One missed requirement can create major problems. The judge is sending a clear message. You are getting a chance, not an escape. That distinction matters. Some viewers will say this is fair and practical. Others will say the offense deserved prison immediately. Was justice served here, or was this too lenient?
All right. This is what the court is going to do. The court will follow your agreement, sentence you to 10 years deferred adjudication. Probation, is Mick available for him based upon what he's charged with or no?
I'll have to double check, Your Honor.
All right. We'll see if the Mick supervision, not really supervision, but I want to make sure they're aware of his mental health issues.
Yes, Your Honor.
So I'm going to put Mick on here, but I realize he's going to be supervised by the sex offender unit. I just want to make sure that they're aware. So we're going to do Mick and the sex offender unit for supervision. There's to be no contact with the complainant. And I'm not going to say the name on the record, but that's the person who's in the indictment. And I believe you know who the complainant is.
Yes, sir.
Okay. There is to be a $1,500 fine that will be probated. So that means that if you successfully complete everything, you won't have to pay that. There's Chapter 62 registration. There is going to be regular reporting by Zoom or in person. So if it's some reason you can't Zoom, which they're probably going to want you to be in person, just speak with them and they'll go over that with you, okay? There's going to be regular UAs. Are we going to have any drug issues with you?
No.
Okay.
Just his prescriptions, Your Honor. But
Okay.
they're prescribed.
Make sure that you give probation your prescription medication as far as the list of everything that you're taking and provide proof.
Yes.
All right. And I'm going to want proof of employment or proof of disability. So if you provide the proof of the disability, then you won't have to get employment. But I'm going to give you 30 days to get that to probation. So great grandparents, he needs to provide them proof that he is disabled, and he needs to give that to probation. And he also needs to give a list of his prescriptions to probation. So proof of disability. And I'm going to require him to reside with your grandparents, okay? So I'll put you to reside with the great grandparents. or grandparents, since you have both here. Is there anything else that he needs? Oh, I'm going to do field visits. And that'll be 2 times per month. I'm not going to add community service hours because there are no community service hours for him. All right, probation, is there anything else he needs? All right, is there anything else you need from the court? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record.
This case shows how complex courtroom justice can be. The defendant faced a serious felony charge carrying up to 20 years in prison, yet the final outcome was deferred adjudication with 10 years of strict probationary supervision. That means the court balanced punishment, risk management, family support, and the possibility of rehabilitation, all while making it crystal clear that any violation could bring severe consequences later. The judge also demonstrated something many people overlook. Courtroom decisions are not just about emotion or headlines. They're about legal procedure, evidence, negotiated agreements, and whether the court believes strict supervision can better protect the public than immediate incarceration. Whether you agree or disagree, this ruling came with heavy obligations and zero room for mistakes. Now we want to hear from you. Did the judge make the right call, or should prison time have been imposed immediately? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
It's going to be very important that you stay in contact with probation, okay? All right, good luck to you.